Welcome. We're here to explain the significance of the Consumer Guarantees Act 1993. The Consumer Guarantees Act has legal repercussions to protect consumers in relation to granting them the rights such as receiving repairs, replacements, or refunds when goods are faulty or damaged. Therefore, in order to avoid litigation issues, it is imperative that small and medium-sized businesses are aware of the laws related to CGA. The Act applies to all consumers who purchase goods and services from sellers in trade for personal, household, domestic use or consumption. Businesses operating in New Zealand who provide goods and services such as online traders, professionals, importers, financial companies, retailers and tradespeople. In addition, the CGA also applies to all those people in trade. Under Section 2 of the CGA, a person in trade is someone who frequently transfers the ownership or the possession of goods to a consumer and supplies services to an individual consumer or a group of consumers.
Who is a consumer? A consumer is someone who acquires from a supplier. This can consist of either goods or services of a kind which is ordinarily acquired for personal, domestic, or household use or consumption. Purchased goods and services by consumers are important. For example, Harry enjoys flying, so he purchased a fighter jet. Harry would not be protected under the CGA because a fighter jet is not normally purchased for household or domestic uses. The CGA conflicts in three scenarios, which therefore decreases its applicability. Scenario 1. If the purpose of the item is resupplied to other consumers through trade. Scenario 2. If it is consumed in the course of a process or production, or manufacturing, or in the case of goods. And Scenario 3. If repairing or treating in other trade goods or fixtures on land.
The CGA provides multiple guarantees for the purpose of receiving expected goods and services properly as a promise to consumers and suppliers. The guarantees are divided into goods and services. Guarantees for goods include past ownership rights, agreed or reasonable time, acceptable quality, fitness for particular purpose, goods comply with description and sample. Guarantees for services include reasonable care and skill, fit for particular given reason, done in a reasonable time frame, and reasonably charged when prices are not fixed or set.
The CGA aims to provide consumers with an acceptable quality of goods or services. When the supplier has breached any of the guarantees of the title, reasonable care and skill, fitness for particular purpose or result, and complying with the description or sample, then the consumer has the right to ask for remedy depending on whether the failure can be fixed or not. If the failure can be fixed, the consumers can require the supplier to remedy the failure within a reasonable time, and the supplier can choose to repair, replace, or refund. If failing to remedy the failure, the consumers can choose to get the goods fixed by someone else and make the supplier refund all reasonable costs incurred in fixing the goods, or to reject the goods and ask for refund or a replacement of the same product. Consumers could also obtain damages for the consequential loss caused by the failure. In A&W Holdings Limited and Hoskin case, a faulty electric blanket started a fire in the consumer's house. Consequently, the consumer was able to recover $57,500 for the damages, inconvenience, and the distress caused by the fire. Usually, the Act does not allow contracting out the CGA based on the subjection to Section 43 subsection 1 and Section 40, 41, and 43A. The provision of this Act shall have effect notwithstanding any provision to the contrary in any agreement. However, in business-to-business transaction in Section 43 subsection 2, there are certain circumstances for business to contract out the CGA. Business can agree that transactions have no rights under CGA if there is an agreement between both parties in trade. To contract out of the CGA, one of the two things must have occurred. The agreement that the CGA does not apply must be in writing and agreed fairly and reasonably, or the agreement is not in writing, and the supplier clearly displays terms and conditions which contract out the CGA at every place of the business. Otherwise, the supplier or manufacturer attempting to contract out the CGA will have committed an offense under the Section 13, subsection 1 of the Fair Trading Act, and that does not worth it to risk.
Breaching the CGA can be quite troubling, especially for small to medium businesses, as a failure to comply can result in a $600,000 fine for all companies, and for individuals, the consequence of breaching the CGA is a fine of $200,000. An example of this is when the Commerce Commission prosecuted the Noah Leamy Group for breaching the CGA and FDA. Noah Leamy made false accusations to the customers about the CGA and falsely claimed that iPhone issues had to be made through Apple directly. Noah Leamy stated the CGA is not effective for the consumer and refused them a refund. These comments by Noah Leamy under the CGA were deceiving. Consumers are entitled to have their issues solved by Noah Leamy as a form of their remedies. Noah Leamy pleaded guilty to 8 charges in FDA and a fine of $200,000 for misleading customers about the rights and abilities under the CGA. Therefore, on these facts, small and medium-sized businesses should be aware of the potential consequences of breaching the CGA. Thank you for listening.